Good afternoon everyone, and welcome to today's webinar regarding the Retail Shop Leases Act, what you need to know. We have 31 agents attending today's webinar. If you have a question, please jot it down and send it through, and I will answer it towards the end of the presentation if time allows. Otherwise, I will contact you at the conclusion of the webinar and post the question and answer on our website. If you are having difficulty in hearing the audio, please let us know by popping that information into the question box, which is on your screen at the moment. In the expectation that you are hearing me loud and clear, I will proceed. Here's my mugshot and a brief explanation of my legal expertise. I'm prepared to speak with any of you on any of the areas of my expertise as detailed here, and invite you to contact me if you have any questions in any areas of the law detailed above. As usual, you know that today's seminar, or webinar I should say, is general legal advice only, and the usual disclaimer applies. I don't need to read the disclaimer, you can read it for yourself. We'll leave it up there for a second. Thank you. Now, getting down to the nitty-gritty, as you can see from this slide, amendments to the Retail Shop Leases Act 1994 came into effect on the 25th of November 2016 as a result of a statutory review. I will be discussing amendments that particularly concern real estate agents, including changes to what businesses are classified as retail shop leases within shopping centres, changes to disclosure requirements in relation to lessors to prospective lessees, assignors to prospective assignees, lease renewals, and business sales. I believe the best way to explain the recent changes is to use an example. In this diagram, you will see that it depicts a number of different tenancies, including the Commonwealth Bank tenancy, Shop 10, on the ground floor level of Bluewater Square here at Redcliffe. For the purposes of this webinar, we will assume that 90% of the tenancies are retail shops, being shops used wholly or predominantly for carrying on a retail business, which is a business prescribed by regulation under the Retail Shop Leases regulations. Schedule 1 lists a number of businesses that are regarded as prescribed retail businesses for the purposes of Section 5C of the Act, and I commend to you that you have a look at that schedule. There has been little change to the schedule between 2009 and 2016 when the Act was amended on those occasions. However, businesses such as those dealing with audio-visual equipment, computer accessories, dishwashers, and a number of others have now been included in the schedule. Businesses dealing with perfumes, as in our next example, or an example to follow I should say, were included in the schedule in 2009. I think the best way to understand the amendments to the Act is to poll some questions to you, and then I think it will be indelibly imprinted on your brain if you get it right, and even more so if you get it wrong. So the question I'm going to ask is this. Going back to our diagram and seeing where the Commonwealth Bank is located on the ground level, is the lease by the Commonwealth Bank a retail shop lease? Now, as you can see from that diagram, in excess of 90% of those tenants would be, in fact, retail shop leases other than for Woolworths, which is a major tenant. Okay, so the vote's coming in. I'll give you another 10 seconds to vote. Okay, we're now closing the poll. Everybody's voted, thanks for that. 81% said yes and 19% said no. You can see the answer down the bottom and I'll explain why. Section 5A of the Act defines the meaning of a retail shop lease. A retail shop lease is a lease of a retail shop. Section 5B states that a retail shop is a shop in a shopping centre or used wholly or predominantly for carrying on of a retail business. Then Section 5A3 says that a retail shop lease does not include a lease of premises where the premises are not wholly or predominantly used for carrying on a retail business, and at the time the lease is entered into, one, if the premises are located on a level of a multi-level building, the retail area is less than 25% of the total lettable area of the level, or two, if the premises are located in a single level building, the retail area of the building is 25% or less of the total lettable area of the building. Now Section 5A4 outlines what a retail area means, and that's defined as, it says the retail area for a level or building in a retail shopping centre is the area of the level or building comprising premises used wholly or predominantly for carrying on retail businesses, and the total lettable area is defined in Section 5A5, which says the total lettable area for a level or building in a retail shopping centre is the total area of all premises of the level or building that are A, leased or occupied, or B, available for lease or occupation. Now, having totally confused you with all of that, all you need to know is that by virtue of the fact that the Commonwealth Bank is sitting on the lower level of this building with all those retail tenancies, it becomes a retail shop in the, it's a retail shop lease, I should say, it's not a retail shop. Going on to the next example, we're talking about Priscilla's Perfumery on level 1. For the sake of this discussion, we will assume that Priscilla's Perfumery occupies shop 37A, where you've got My Health Team at the minute, which represents only 10% of the total lettable area of the level. All other shops, there's Healthworks, Gleeson Klein, Parker, Cooke Hutch, the Redcliffe Member of Parliament, Yvette, Darth, and the Blue Water Square Centre Management are not retail shops. The question then is this: is the lease by Priscilla's Perfumery on the first level a retail shop lease? Okay, polls coming in. Okay, 88% are in, 94% are in. 10 seconds for the rest before we close her off. Who's not voting? Okay, we'll close it off there. 60% said yes and 40% said no. Okay, move to the next slide. The simple answer to this is that Priscilla's Perfumery is a retail shop lease because it's a prescribed retail business. I could sit here and talk to you for 10 minutes about this, but at the end of the day, if you've got a standalone retail shop amongst a heap of commercial shops these days, you still must give disclosure statements, etc., to that particular tenant because they are a retail shop lease in the eyes of the new legislation. Okay, moving on. I guess what I've got before you at the moment is just an explanation of what we've already discussed and you heard me talk about a minute ago. And given that this is only a half-hour webinar, I think we'll move on. That will be in your slide material. You can look at that at your leisure. We just want to talk about options in retail shop leases. Now, we've already established that the lease of the Commonwealth Bank downstairs is a retail shop lease. Not a retail shop, but it's a retail shop lease, and the lessor must comply with the provisions of the Retail Shop Leases Act so far as disclosure, etc. is concerned. Now, the Commonwealth Bank has a 5x5 lease that expires on the 30th of June 2017. The bank exercises the option. Is there an obligation on the lessor to provide a disclosure statement upon exercise of the option? The poll's now open. %81 have voted. Okay, we're up to 94%, are we? 94% have voted. Okay, well, not of those that voted, 93% said yes and 7% said no. So the answer's on the next slide. Previously, there's no requirement for a lessor to give an updated disclosure statement for any option periods exercised by the lessee. However, there's a new section 21E which requires the lessor to give the lessee a current disclosure statement within 7 days of receiving the lessee's notice exercising the option. The lessee has the right to waive the lessor's obligation to give a disclosure for the lease. Why anyone would do that would be beyond me. The lessee now has the ability to withdraw the notice exercising the option within 14 days of receiving the current disclosure statement. So if the lessee is not satisfied with the contents of the current disclosure statement, the lessee can withdraw from the option. There are no specific grounds for the withdrawal. It is a general right for the lessee. And the lessee may change its mind, re-exercising the option without any recourse whatsoever. It also means that a lessee has the chance to make a fully informed decision as to whether or not it should renew the lease, having regard to the lessor's updated disclosure. This updated disclosure, as you know, will provide details of any planned renovations or redevelopment, as well as the expiry dates of major or anchor tenants which may impact the lessee. For example, if the tenant downstairs in the bread shop found out that Woolworths were not extending their lease, or if they knew that the lease was only running for another 12 months, they might be less inclined to, once exercising the option, they might be inclined to give notice that they've withdrawn the notice of exercise of option and move out to another centre. Okay, the next scenario we've got, as the bank is a retail shop lease, the lessor is required to give a current disclosure, which is an updated disclosure statement. And as I said before, the bank has the right to waive it, and there's no point dwelling on this because we've already explained that in the previous slide. The next thing I want to talk about is a lessor's disclosure obligation to a prospective lessee. Now, this is just the standard procedure where you've got a lessor of maybe an arcade of shops, all of which are going to be retail. So what's the situation now, and how is it different to before? It is a bit different, but it's pretty much the same. So the Act now provides that a lessor's disclosure obligation to a prospective lessee is that at least 7 days before a prospective lessee enters into a retail shop, the lessor must give the prospective lessee 1, a draft of the lease, and 2, a disclosure statement. Nothing's changed. However, for the purposes of complying with subsection 1 in relation to a disclosure statement, it is sufficient if after the prescribed disclosure date, which is the 7 days before, the lessor gives the prospective lessee the disclosure statement, the prospective lessee gives the lessor, I should say, a waiver notice, and unless the prospective lessee is a major lessee, a legal advice report from a lawyer stating that the lessee has taken advice as to the legal meaning effect of the waiver. Please understand that the waiver notice is only in relation to time. It is not in relation to the obligation to give the disclosure statement. So you must still give the disclosure statement and you must still give a draft copy of the lease, but you do not necessarily need to give it 7 days before. That's a win for you guys, as you people as real estate agents, in my view. However, be aware that if you don't give the disclosure statement or a draft copy of the lease, then you've got problems by virtue of the fact that the lessee has got the right within 6 months after entering into the lease to actually terminate and walk away. Now, one of the other big things is here about defective notice. Now, defective disclosure now means it's incomplete in a material particular. Previously, it just said incomplete, so you could just leave out some very minor thing and still it was ineffective. It's not ineffective unless a material particular is incomplete or it contains false or misleading information in a material particular. As I just said previously, if it was just incomplete or false or misleading, then the lessee had the right to terminate. But these days they don't. So it's no longer defective, even if the layout in the approved form is not 100%. But I'd suggest you follow the approved form to the letter so that you don't get yourself into trouble. Okay, moving along, we're looking at disclosure for entering into an assignment of lease. Now, the new section in the Act says an assignor and prospective assignee's disclosure obligations to each other are that an assignor of a retail shop lease for a lease shop must give a prospective assignee a disclosure statement and a copy of the current lease at least 7 days before the earlier of the following. A, if the assignment is related to an agreement for sale, please note that, to the assignee of the assignor's business carried on in the lease shop the day on which the assignee enters into the agreement, and B, the day the lessor is asked to consent to the assignment. So rather than baffle you with mumbo jumbo, and there's plenty of it in the Act, let's just, we'll go forward and I'll explain this in a slide about 2 down the track, but we'll go to the next slide just so you can have a look at where you can get your disclosure statements, because we've got 10 minutes to go before we finish this presentation. Please be aware that what is displayed on your screen now is the updated version of all disclosure documents required under the Retail Shop Leases Act. I suggest that you look at the that website down the bottom, and that will make sure that you have got the correct information. If you fill out a lessor disclosure statement or an assignee disclosure to lessor or any of those documents in the old version, then you're going to be in trouble and you're going to have a very disgruntled landlord. Okay, moving on. Let's have a look at the ground floor here at Bluewater Square, and let's say that Ray's patisserie decides to sell. Okay, so here we are, we've got a poll question here. We don't have a poll question, I'm sorry. Okay, so you're going to have to think about this anyway based on what I've just said. Agents prepared the contract. Has a buyer keen to sign the contract? Are there any problems? Can the buyer sign? Yes or no? I'm going to have to answer the question for you. Just do your own poll and tell me what you think based on what we just discussed before. The amendments introduced modifications to the disclosure requirements in assignments of the lease. In a business sale, disclosure must be given 7 days before the earlier of the buyer signing the contract or the lessor being asked to consent to the assignment. The buyer cannot sign the contract until 7 days after receiving the assignment or disclosure and a copy of the lease. How practical is that? Not very practical, I can hear you all saying. Can I suggest that if someone wants to sell their business, the very first thing that you ask them to do is to give you a copy of the current lease, signed by all parties and dated, not something that was part of the negotiations that might have been changed and is not a true copy of the lease. That's the very first thing you should do. The second thing you should do is tell your client that you need an updated disclosure statement. And we all know these take time to get. So encourage your client to get onto the landlord and ask them for an updated disclosure statement. There is a waiver provision in here as well. The buyer can waive the time frame for provision of disclosure. Again, the time can be waived, but the obligation can't be waived, and the solicitor has to give a waiver certificate. So technically speaking, you can sign the contract on the same day as you receive the disclosure statement and a copy of the lease, but only if the waiver's been signed off by the buyer's solicitor. A very important thing for all agents to know is that you shouldn't draft your own clauses in leases or tenancy agreements. Now, I'm talking today about retail shop leases. Retail shop leases include retail shop leases which have been prepared by the Real Estate Institute of Queensland and apply in a lot of cases where the lease is for something less than 3 years, as you all know. Today, I haven't talked about those situations at all because I've spoken about those previously, and I'm here to tell you about the amendments. But it's very important that you remember that you shouldn't be drafting your own clauses. That's effectively the end of my presentation. If there's any questions, I'd invite you to put them in now and I'll see if I can answer them. There's none down there at the moment. No questions. I know it was short and sweet. That was the intention of it. I hope you have gleaned some information from today's webinar which will assist you in relation to obligations under the Retail Shop Leases Act. If you need to ask any questions about the Retail Shop Leases Act, I'm more than happy to answer those questions, and my details will be, there's a question coming in, I think. Is that right?
Stephanie had a hand up, but she's gone.
No, everybody's left me. Okay, thank you. And where to from here?
Stephanie's just, she couldn't get it working.
There's my contact details. Thank you for attending today's webinar, and hopefully we can be of some assistance to you if the occasion arises. Have a great afternoon. Thank you. Hold on, I've got one here. If a solicitor does up all the documentation, if this is incorrectly done, would this come back to the agent? I would assume not. Answer, you're right. It'll fall on the solicitor, not on you. But what you should do is tell your client that these are the documents prepared by your solicitor and you've had no input into them and you're not his agent. You're just following the instructions from the client. But no, Stephanie, you should be clear on that one. Okay, all the best everybody. Good afternoon.